Hey, Derek, we're playing golf. Might be a couple. Here's all my plans. Tom probably, I guess. Fortune was saying about
it seems to me that we're missing a table, but I'm not here.
Let's see if I gotta watch it.
Hey, Bo, are you going to us?
I don't care, and then we're going to play with, I think they have a regular Fortune. Okay. I'll find out tomorrow. In,
no, I'm going this week.
Sports
for I thought you were going to
yeah, I do. In the morning. That's good.
I'm going to the federal law defense one.
What are you playing?
I think it must be a while before I need different places called Spivey and Ainsworth. Spivey and Ainsworth? Yeah, I just started that.
How many hours?
Yeah, they want me to work 20. I don't know how long that's going to last. I told them about this deal, so they're going to be flexible with that, you know, spontaneously show up.
Huh? Can we get that out of there for you? How's your wife doing?
Good.
She's
pregnant.
Oh, congratulations.
That's great. We got to have it around finals, so I didn't have
it.
Great time.
So she's pretty far along now, huh?
Yeah. Middle of December. So I'll bring the old rub right up here next semester. I'll make sure y'all don't rub out too much. Boys.
Oh, boy. I didn't think you had an name here. Yes, you do. I read that.
I wonder if they do.
So they tell you, well, they tell you which coach or what. It's not in detail.
That's the best I've seen.
That's what you led me down there. That was 3/4 of our game. Russell Thomas. Or what if this one, when you can do the corner? Yeah, you're like, what? 5 foot 10, 100. I walked in and anyway, it's more of a lot just fear and praise than, anyway. The problem is you should have fucking told us you fucking hug the skin. Dude, no, but how is it hot? North Texas, man, I hope your curse is with me. I They play good though.
First plan gets started. Ken Howell won't be here this evening. He decided he had something better to do, so he's just going to do that instead. No. He had a good excuse. He was for some time, we've had a serious problem in the clinic that we haven't had good computers there. There has been a proposal submitted that gives 6 really modern, high-speed computers for the clinic, and if all those well, we'll have them before the end of the month. But until then, bear with us. The next issue is to require even more bearing with us, and that is that we don't have a copier in the clinic. We don't have a copier on the 4th floor. We don't even have a copier anywhere in the whole Connolly building. And I don't know what genius figured this out, but it's a serious problem, especially when you have a need lots of times just to make one copy of the letter you sent to a client or something like that. But there's going to eventually be a big copier on the 1st floor, but I still don't think that's adequate. I'm trying to get kind of a little or medium-sized copier in the clinic just for little jobs. And if you have a big job like photocopying with motion, it's multiple copies you can go downstairs. But anyway, please be patient. I'm working on that problem as well.
This is an example of how the law school trains you in its triage method of education, and that is that what we are teaching you all to be is law professors. And if you can't be a law professor, we may be able to get you a job as a federal law clerk someplace. But God help you if you have to actually practice law. We don't know anything about that. We don't build buildings that can have copiers, and actual resources for law offices is just beyond our imagination. That's why we build appellate courtrooms when we build courtrooms. We don't know that somebody might actually have to testify. Or in the case of this court, go look at the witness box in this courtroom over here sometime. And you will notice that the witness chair sits on a box like that. And that's because when the geniuses from the architecture school and the law school got together and designed it, the chair was so low, when the witness sat down, he disappeared. There was a big wooden wall.
Even big witnesses like Bill, they sat in the chair and they just disappeared out of sight.
Ken,
Okay.
Ken, not to take any wind out of Mr. Allison's argument there, but I was just, I'm sorry,
I
Bill,
realize it's hard. And I have to work on it.
but I know the VOA is offering their copy machine to everybody in the Connolly Center until something, I don't know if you've tried that or not, but I mean, that is an option.
Peggy did make that offer. I didn't realize, she made it to me, I didn't realize it was for everyone.
Well, I didn't mean to, I mean, I'm sure not volunteering. I don't know what Peggy's said to you, but...
Why don't we just, there is a copier in the Board of Advocates, and if you need something, it's on the 1st floor, on the west side of the 1st floor. If you need something, try going down there for a while, and Peggy runs BOA, ask her if it's a problem, or just go ahead and use it if it's a small thing, and if it's a problem, she'll let us know. I'll talk to her about it, too. I'll make myself know. And I will let you know if it's a problem. Okay. Email is going to start flying furiously around here, so make sure you check your email at least twice a day. I realize it's hard to check your email twice a day when you're in the clinic and you don't really have access to a decent computer, but hopefully that is going to change with time.
Are there Ethernet ducts that we can hook up to in the clinic?
You're the techno.
The answer is obviously no. That's going to be the same always.
Well, they have them in the.
They just advertise,
clinic, so I didn't know.
What
that-
kind, what,
That's a networking.
It's just like a phone line, it's faster and it puts you directly into the network so that we can check our email from our own computers.
I assume we have similar setups as Children's Rights, but I may be wrong. Why don't you just look around and see if you can find something?
Okay.
Find out.
I'll just call and ask them if they're hot.
Talk to Children's Rights and see if they can something.
And send an email if you find out.
I will.
Okay.
Okay.
Using that Jackson and email, then we'll know.
There you go.
One thing we didn't talk about last week is the clinic's one loss record. Bob Dawson used to keep a one loss record for the clinic every semester, and in order for a case, the outcome of the case to be considered a win, we had to get a disposition of the case that would be expungible. In other words, where we could go and get the client's record erased. Over time, there have been, for many, many years, we were winning about 67% of our cases. In other words, 60% of the time, our clients were eligible to get their record expunged. I think the going has gotten a little tougher in recent years. We stopped taking some of the cases that were easy wins just because they weren't challenging enough, and the county attorney's office has gotten better about prosecuting PWI, and the cops have gotten more trained. But even so, we have one of the best one-loss records of any criminal defense attorney in Travis County. So even though you may start off thinking that you don't really know what you're doing, which is probably true, the reality is that by the end of the semester, you will know what you're doing. And we have something special here, which is we're not constrained by economics here. In other words, if somebody can only afford $500 worth from a lawyer in the private sector, most of the time that's all they get. If somebody can afford our $30, they'll get whatever it takes. If it takes, 100 hours of investigation or 100 hours of spending time in the library researching stuff or writing, whatever it takes, we do it. On top of that, if necessary, we have money to hire expert witnesses and things of that nature. Plus, there's all the synergy of all the supervising attorneys and instructors. We all have different backgrounds and strengths and weaknesses, but together, we're very powerful. So even though you may feel individually weak, take solace in the fact that collectively we are a powerhouse. One of the things I hear every semester at the end of the semester is that, gee, I hate to call the supervising attorneys at their office because they're so busy and they've got a law practice and I just don't want to disturb them. Well, the law school doesn't pay them a lot, but it does pay them, and that is their job, and that is my job, to field questions from you. So I don't want to hear any of you say at the end, well, gee, I didn't think it was okay to call them. That's what we're here for. We are here to answer questions you have. We don't know when you have questions. You need to take the initiative and ask them. I also want to say that we generally tend to think alike about how cases are to be handled, but if you ever come to me, for example, and I suggest one thing and your supervising attorney suggests something different, you need to do what the supervising attorney says because they're the attorney of record on the case and ultimately it's their responsibility about what happens. But I don't expect that to happen very often, and usually I have a good sense that something's kind of questionable. Sometimes a question comes up, do you give your client your own phone number? Depends. I would recommend that you use judgment in making that decision. When I was in the clinic, I didn't use judgment, and I once got called at 4:30 in the morning by some drunk who had been arrested and wanted me to come get him out of jail. Some clients, it's your decision. You do not have to give them your own phone number. I can tell you that if the only number they have to contact you is at the clinic and you're not up there much, it's going to be hard for them to get a hold of you. So you just have to figure that one out. We always ask people that are coming in for financial inquiries to bring all their court papers with them, all their bond papers and court assignments. What I've noticed is that when people bring all these papers in for their financial inquiry, that students are reluctant to take possession of them, thinking that the client needs them. they're much safer with us than with the client. You want to get the papers from the client as quickly as possible. If the client is insistent on having some of them back, try and get away from making copies of the documents and giving it back to the client, but let us keep the originals because we need all that stuff. It has been a tradition in the clinic for a long time that after this coming Thursday's class, we all go out after class for casual time. In the past, what we've done is we've gone to a place like Schultz's or Jaime's and sat around and drank beer and ate nachos or had dinner. And the tradition is that the instructors pay for the beer and the students pay for the food. Well, I got tired of eating all the greasy food in places like Schultz's. I wanted to have a decent meal as well, so I kept tinkering with this process. More recently, what we've done is we've worked out a deal with Calabash Caribbean Restaurant where we can go over there and they'll set up a table for 20 of us and they'll serve us a meal family style, and they'll also serve us iced tea and beer by the pitcher. Now, doing that is obviously a lot more expensive than just paying for the beer, and from our point of view, it got out of hand financially. So I'm trying to find a way to make this work for everybody where you can have all the food and drink you want, and I can have a good meal, but we don't end up getting stuck for a small fortune. So what I'd like to try is that you're all invited. If you're in a position financially to throw in $10 for the food and drinks at the end, fine. If you're not, don't worry about it, and hopefully there'll be enough people contributing $10 plus what the supervisors contribute that we won't end up getting stuck for a large amount of money and having to wash dishes. But anyway, it's after class this coming Thursday. Usually we probably get to the restaurant around 5. Class will end at 5:30. We get to the restaurant around 5:45, and we usually stay there a couple hours and sit around and talk. I'll see if I can persuade Holly to come, but I don't know whether she's well enough to yet, so we'll see. Okay. Does anyone have any questions about chapters 1 through 3 of the manual? Okay. Dave is going to talk to you about the court docketing system in Travis County. There are 2 docketing systems. One is the county court system, which is the one you deal with most of the time, and it's very confusing to me, but by the time Dave gets through talking, all of you will understand it. So,
right. Assuming I do. One thing y'all will quickly come to learn when you graduate from law school and go out and start practicing real law is that wherever you go, there's going to be a unique docketing system in the courts. Every jurisdiction handles their docketing and case control system in a different fashion. They generally tend to look alike just because that's the way the world works, but they're all unique and have their own idiosyncrasies. Some of them are historical reasons that don't really have any justification anymore. They're just anachronisms that still sit there, but they affect the system. Sometimes they're fairly new and they make a lot of sense. These are basically what are called the local rules. Now, as you know, if you've been in the bookstore, you can buy a set of all the local rules in the state of Texas. There's actually a formal procedure for that, where the local presiding judge and the other judges get together and draft up a set of proposed local rules. And those are submitted to the Supreme Court, and then if they're approved by the Supreme Court, they become effectively binding rules for the local practitioners in that county. Now, in state court, these tend to break down by the county because that's where the jurisdictions are. In some, particularly in the smaller jurisdictions, you will find that you have multiple county sets of local rules because you'll have, say, one district judge will have more than one county as their jurisdiction. They just don't have the population to justify a full district judge in each county. Out in West Texas, you'll often find 3, 4, or even 5 counties that will have just one judge, and that judge will impose a set of local rules for that whole 5-county region. So you've got to be aware of that, and then of course you're going to have a different set of rules for your district courts, and then a different set of rules for your county courts, because those are different judges, and they have different kinds of cases, and they have different procedural issues. You also have individual sets of local rules in your your federal courts. Those are generally broken down by divisions within the district. Texas has 4 districts in Texas: northern, southern, eastern, and western. And then each of those districts has divisions in it. For instance, Austin is, the Austin judges we have here are 2 federal judges, are the Austin division of the western district of Texas. They have their own set of local rules, and then each judge within that, as a practical matter, has his own set of rules. Judge Allen does things somewhat differently than Judge Sparks does. Judge Sparks, for instance, has a rocket docket, as it's affectionately known. You get a case indicted into his court, it's going to get tried fast. I was once picking a jury 33 days after indictment in his court. I think Jim Allen has made a life's work of not trying any case. Like a good wine, you don't try no case before it's time. You try to let a little age and get on everything. It's just a different style. The important thing about this is, once you get out there practicing, you have to know what those local rules are, because it affects your case. You may, for instance, look at the Code of Criminal Procedure in a criminal case and see that the pretrial motions are due 7 days before the pretrial is scheduled to be timely filed. And if you rely strictly on that, in most cases that'll work just fine. But there may be a local rule that is a binding local rule with the court that you've got to file your pretrial motion sooner than that. And if you aren't aware of that local rule and you miss that timetable, then you can be out of luck. You can be looking at a malpractice issue because you weren't following the rules. In the real world, it becomes very difficult, because not only do you have your written local rules, as a practical matter, you have a whole set of unwritten local rules, which is how it really operates. You know, they've got these formal written rules, and sometimes those are 5 or 10 years old. And as time goes on, the system kind of changes and adapts to whatever the new stresses are on it. And nobody writes that down. It's not written anywhere. But that's how it really works. And you need to know how these systems really work so you can be an effective advocate in these systems. How do you figure all this stuff out? As a practical matter, it's impossible as an outsider to come in and learn both the formal and the unwritten local rules that apply in every jurisdiction. What we do traditionally is we hire local counsel. If I've got a case, for instance, recently I had a case up in Hamilton County. Well, I've never been to Hamilton County. So I looked around and found a very good criminal defense lawyer up there, a lady named Joy Alexander, who's quite capable. Hired her, and she served as local counsel and just let us know what was going on and how we had to do things. In addition to kind of those rules, formal and informal, she informed us of the personalities and introduced us to people and kind of got us into the community so we can do what we needed to do. That is a very standard part of trial practice around the state. If you're practicing law in a big firm in Dallas, Texas, and you get a case down in Brownsville, you better get you some local counsel on board who knows what the hell's going on and who the personalities are. You're liable to step into a big time and never know what you're doing.
In a lot of federal courts, they make you. You can't just walk in, even if you're admitted. You know that you can't walk in that local counsel.
Well, in the Western District, the rule is if you are not already admitted to the Western District, and I don't know if y'all are aware of this, but once you're licensed in the state of Texas, you're formally admitted to every court, state court in the state of Texas automatically by virtue of being licensed as a lawyer by the Texas Supreme Court. In federal court, however, you have to be individually admitted into every district. That's 4 districts in Texas. God knows how many that is across the country. And you have to make a formal application with supporting letters and everything. Each one of those districts, every district you want to practice in, you have to go through the process of being reviewed and formally admitted into that court. Usually you have to either pass a test or attend some sort of seminar before you can even make the application.
The same thing in the federal courts, the federal system.
Yeah. And they just got completely off track with all things. It's just amazing. Just take the record back the first time. Where was I? Anyway, in some of these courts, you do have to be admitted formally. The Western District, for instance, if you are not a member of the Western District of Texas and you're admitted to practice pro hoc vice, which means you're just going to come in and try this one case, you don't want to go through the process of being formally admitted full-time, And you'll do this if you're going to say, you get one case, you're practicing in Texas, you get one case in Ohio. The odds of you ever going back to that district in Ohio are pretty slim. You go in pro hoc vice just for that case. But most of the federal courts will require that you retain local counsel, and they have to sign on as local counsel before the judges will let you appear pro hoc vice, just because they don't want you bumbling around and not knowing what the local rules are. Okay. Having said that, we have a set of local rules, both formal and informal, for the county courts you're going to be practicing in. 95% of the cases you handle will be in the county courts of Travis County. There will, in unusual circumstances, be a few cases down in the municipal court of the city of Austin, and just maybe an occasional case on one of the JP courts. We're not going to talk today about either the municipal courts or the JP courts, because those are so unusual that when you get a case in that, your supervisor will sit down with you and discuss how that works. They're kind of strange systems. We're going to pay attention to the 95% of the cases which go into the county courts of law. If you will turn to page 1-13 of your material, you will see a chart that tries to simplify what will at first seem to you to be a rather confusing system, which actually makes a lot of sense. We try to set this up. Up on the top row up there before you get to the grid system, you'll see the county courts listed there as 3, 4, 5, 6, and 7. County courts 1 and 2 we don't go to as a rule because those are civil county courts. You may occasionally go there for an occupational driver's license, but that would be rare. So we don't go to those courts as a rule. Criminal courts are 3, 4, 5, 6, and 7. You probably will not go to county court number 4. That is a special domestic violence court. That's where the family violence assault cases go, and we are not taking those right now. We're trying to work out an arrangement with Judge Denton, the presiding judge of that court, to get us involved in cases that he is confident will go to a hearing. Very few cases actually go to a hearing in that court. I talked to Judge Denton last week about this, and he is willing to talk to us about setting up a system where when he's got someone that needs an appointed counsel, maybe they're in jail and they're just headed for a far sure trial, then he's willing to think about trying to appoint the clinic to get involved in that so y'all can get the trial experience. But right now we haven't set that up. We'll try to do that in the next couple of weeks if we can. Otherwise you may not see court 4. County court number 3, 5, 6, and 7 are all right now located on one floor of the annex to the courthouse, which is a recently new building behind the old original courthouse. You have a map. I think we go down there next week, is it? We'll actually be down there and we'll show you the 4 courts. It's actually a very convenient arrangement because all 4 of them are on one floor, and it's set up really well so we can bounce from one court to the other just by really walking across the hallway. It's just a few steps. So don't panic when you get assigned a case and you look on your docket and you realize you've got pretrial hearings on 2 cases at the same time on the same day in 2 different courts, because those courts are only 50 feet from each other. So that'll work out all right. You're not in separate buildings like you can be in some counties. Now, when someone is first arrested, let's start in the top left-hand corner here where it says arrest and follow the arrows, and then I'll explain how this chart works and then you can refer to it. Don't expect for this all to make sense the first time through. The first 2 or 3 cases you handle, be sure to walk through the process with your supervisor and make sure you understand how that specific case is going to process through the system. After you've done that once or twice, you'll suddenly go, oh, I see, it all makes sense, and then after that you'll have it. You won't have to worry about it. But don't be shy about asking about this because it's a little confusing to an outsider. Everybody's arrested in the county of Travis. It does not matter who arrests them. Sheriff, DPS, City of Austin, Rollingwood, Sunset Valley, doesn't matter. They all go to one central place. It's down there at 7th East 35. Some of you may be familiar with it. It's down there, conveniently located near 6th Street, where a lot of the business comes from. That's central booking. Everybody goes in there to go to jail. And you'll notice there we'll draw an arrow down and we're just going to follow that column down underneath where the arrows come out of central booking. And we're going to talk about what happens there when someone first gets booked in. And then we'll, as we progress to the right of this chart, we'll talk about each subsequent stage of that case. So the first thing that happens in central booking is where the arrest and the charging and the bonding takes place. They're arrested, they're put in there, and the officers file the initial charge with the judges down there. Now, the judges are municipal court judges. Being magistrates, they can accept any level of charge in criminal cases. They only have ultimate jurisdiction over Class C misdemeanors, but they can accept the initial complaint on Class C misdemeanors, A and B misdemeanors, and all felony cases, even capital murders. As magistrates, they have that function. They also set the bonds on all these cases, all the initial bonds. And they have a standard set of bond rates they put on these things. The location is in the municipal court. The municipal court building is actually in the very same building as central booking and the Austin Police Department. If you go down there to the IH-35, the 7th Street side is municipal court. If you've ever gone down to pay a traffic ticket, that's where you go in, and that's the only access y'all will have to it. Just on the opposite side of the building, on the 8th Street side, is the Austin Police Department. And then once you get inside the building, you'll suddenly start to realize there's all sorts of little passageways in there, but most of those are sealed off because the police department is a secured area. You will go in through the 7th Street side of municipal court. That's where the judges will be. That's where they'll be setting cases. Most likely you won't have to go down there, but in case you need to go down there and get some of these papers we're going to talk about, that's where you go. The calls number will be, the first calls number will be a municipal court calls number. They give it their own calls number. It's a 6-digit number. It'll be the number on the personal bond or whatever bond they get. That'll be the initial number. That number will change later on, and we'll talk about it. But at first, that's the initial number that's on the personal bond. So when you look at the files you have, and we'll go over tonight, if you look on the personal bond, you'll see on it a 6-digit number that is different than the ultimate number you're filing your pretrial motions and having your hearings in, even though it's the same case. And I'll explain why that happens. Physical appearance required, well, it doesn't apply down there. I mean, your client's already there. He's locked up. And you don't, most of the time, this process is all taking place long before we're involved, weeks before we're involved. When the phone, well, don't pay attention to that. That's not applicable. But here, pleadings available. There are some important pleadings. The complaint is filed down there, and to support the complaint, the officers have to file a probable cause affidavit. Look in your files that you have right now that have been signed to you, and you'll see that probable cause affidavit. Some of them are pre-printed check-off, fill-in-the-blanks kind of deals that don't get, like the DWIs. Others require a written narrative by the officer on unusual cases like a criminal mischief or other cases like that, criminal trespass. They're going to have to probably write out a narrative. Those are public record. You can go down there and they'll charge you, I think, 50 cents a page to get those. And if the client comes in and hires you and hadn't been gotten into county court yet, you can go down to municipal court and you can get that. And it's like getting a shorthand version of the offense report real early in the case. It's good initial discovery. Back to our office, if someone calls us and says, look, I've been arrested on a misdemeanor case, I want to come call you about hiring you, we ask them to read to us over the phone the municipal court calls number, so that before they come in for their appointment, we can run down there, send a runner down, and get a copy of that probable cause affidavit, because that gives us an initial set of discovery on what the facts of the case are as alleged by the police officer. So if you need that, that's a real good place to get it. Who subpoenas? Well, there aren't any hearings down there. The only thing that happens is arrest, complaint, and the bonding out. There are no hearings down there as a practical matter. And there are no forms to file. Okay. Now, the next big step that happens is the person is charged with a complaint, right? It cannot go into county court to be prosecuted on an A or B misdemeanor under Texas law until another pleading instrument is filed. It's the misdemeanor version of an indictment. Does anybody know what that's called? An information. That's right. I wish it had a different name because that always confuses everybody, particularly clients. We say, well, the information hasn't been filed yet. They say, well, we've got the offense report. What other information do you need? Well, the information is the technical name for a charging instrument, whether it's a felony or misdemeanor, simply signed by the prosecutor but not by the grand jury. The grand jury can issue a misdemeanor indictment and does so on a regular basis, but it's not required by the Constitution. Indictments, of course, are required by the Constitution on felony charges. So until that information is filed by the prosecutor, the case can't get into county court, and it just sits in this limbo status. So that they don't lose track of it, the judges have created a system of what they call the first appearance system. Many counties have this. It's a way of keeping track of the case until the prosecutor gets around to filing the information and gets into county court. So the first appearance is the first appearance date that is on their bond. That's when they tell the defendant, you've got to appear under the terms of this bond for a first appearance. That is routinely set 3 weeks from the date that they're bonded out. At 9:30 in the morning. So let's follow first appearance down that next column. It's at 9:30 in the morning. Where is it? It's on the same floor as the 4 county courts all we deal with. It's room 255 of the courthouse annex. It's just a little business office. It's not a courtroom. Even though it says you have to appear at 9:30 in court, it's not a courtroom setting. What is the cause number? Well, it's still the same municipal court cause number because it hasn't gotten a new one yet. Physical appearance required? No. Your client does not really need to be there. You don't need to be there. When to phone? You can do this by telephone. Well, it's the one time that you don't have to be timely, and it's a little confusing. You can call 3 days before. You can call the day of. You can call 2 days later. It doesn't matter because it's not a real court appearance. It's the only time we will tell you you don't have to be absolutely strict on the timing of this. What it is, it's just an office with about 4 clerks sitting there at computer screens, and when the people walk in who don't have lawyers, they just give them the information they need, and I'll tell you what that is in a second, and send them back out. The lawyers don't show up there. The lawyers call. Do not call them in the mornings around 9:30 because all the civilians are walking in and tying them up. Call in the afternoon. The phone number is in your materials, and what you'll do when you call them is say, "Hi, I have a case. I have a first appearance," and they'll say, "What is the number?" The number you want to give them is that complaint number from municipal court. You read it to them on the phone. You'll hear them type it in, and they'll pull it up on the screen. Now, one of 2 things will happen then. If the county attorney has done their job and filed the information, and it's gone into the clerk's office and it's been assigned a new number, they will give you the new cause number, which is the county court cause number that will supplant the old number. That will become the operative number of the case. And they will give you an announcement date and a court that it's assigned to. So what they will say, okay, the new cause number is 555-231. You have an announcement in court 4. Let's say it's assigned to court 4. You write that down, you say, "Thank you very much," and you hang up. You put that on your calendar immediately because that's a real court setting. And you understand from that moment on, the old cause number disappears out of your mind. You don't use it anymore. For all your pleadings and everything else you do, it's that new cause number and that new court number. Okay? Now, it is possible that they will say, "You have another first setting 3 weeks from now," and they'll give you a date of the next first setting because the county attorney has not yet gotten the information filed, and they have to keep it in this same loop until that information is filed. That'll probably happen about a third of the time when you call up. And then you just wait 3 more weeks and you call up and do the same thing again until the information is filed. Sometimes you may have to do it 2 or 3 times. It really slows the case down, but there's nothing we can do about that. Okay. Once they give you that new number, the case has been filed and you have the new number, if you go down there, what you can do, you can go to the county clerk's office where it was filed, and you can get a copy of the new information that's been filed, and it will have a carbon copy of the information, which is a new complaint. And you say, "Wait a minute, there was already a complaint filed." Well, there was, but they filed a new complaint with it because they have computer carbons. And they do that because sometimes they change the charge a little bit, or the wording of the charge. And basically the rule is the information has to be supported by essentially the same complaint under the information. So it's not that they have any problem with that, they just generate a whole new complaint. Sometimes it's word for word the same as the old complaint, but it doesn't matter. That's the new complaint, that's the one that counts. All right? Go to the clerk's office and you get a copy of that, and those will be the pleadings we'll be dealing with in court when we're fighting with the case or going to trial with the case. Who subpoenas? Well, there's no hearings of this. First appearance, so nobody subpoenas and there's no motions to be filed or anything. Okay, let's go over one more column. So the case has been set for an announcement. What that means is they want us to announce to them what our intentions are, what kind of setting we want in the future. They do not want us down there. They don't want our clients down there, and they don't want us down there because it's crowded and it's unnecessary. But you have to do this very timely. You've got to call before the day of the announcement. It's at 8:30 in the morning. Announcements in the courts are at 8:30 in the morning. Whatever county court it's been assigned to is the appropriate county court. The cause number, of course, as we're going down this column, is the new cause number in county court. Physical appearance required? No. Do not go down there and don't have your clients go down there. When to phone? theoretically, you could phone between 8 and 8:30 before the docket is called and reach the court coordinator and announce to the court coordinator. The odds of that being successful are virtually zero because the court coordinator shows up, she's making coffee, she's talking to the judge, they're talking about how goddamn hot it is outside, what the kids did in school. They're not answering the telephone, they'll have it on an answering machine. Don't do that. Call the day before, call 2 days before in the afternoon. When you're trying to reach these court coordinators, they're in court with the judges all morning long. Try to reach them in the afternoon, you'll almost always reach them. They're at their desk. Now, I would say to play it safe, call them a couple of days ahead of time. Now, if you call and you can't reach them 2 days ahead of time, you call the day ahead of time, you can't reach them, you call that morning, you can't reach them, you look at your clock, it's 8:30 and you haven't reached them, you're going to have to just get out there personally and go down there and walk into the court coordinator and say, I have an announcement this morning, your client doesn't need to be there. I have an announcement and I want to set it for a pretrial. And they'll say, okay, fine. Wondering, why did this dummy come all the way to the courthouse for an announcement? That's law students, you know. So if it happens and you can't reach them, you're just going to have to get down there and do it. Don't get dressed up just to do that, but get down there, all right? But try to save yourself the grief of doing that. All right. The kinds of settings, and you will talk to your supervisor before you do the announcement of what kind of setting you want. 95% of the time, you'll want to announce for a pretrial. We pretrial almost every case. There are some situations where we look at the pleadings and we realize that unless they change their pleadings, they can't prove the case. They have somehow screwed it up so badly that if we can get them into trial and sucker punch them, we'll win at trial because they pled something so badly and so wrong. So we'll win it. And we don't want to alert them at a pretrial that they got a problem. So every once in a while, we'll make a tactical decision to skip a pretrial and jump right to the trial setting. You'll always want to talk to your supervising attorney on the case before you make the announcement for what kind of setting you want. Okay? If for some reason something happens and you can't reach a supervisor, it's a brand new case, it just came in, and you got to call and you got to get that setting, you can always set it for pretrial setting, and then if we need to change it, we'll change it later. That's your default setting, is a pretrial setting. Some of the courts have two kinds of pretrials. We'll talk about this later. Have two kinds of pretrials. One is a pretrial without witnesses. One is a pretrial with witnesses. If you're questioning which one you want to do, set it for pretrial without, because we can always then move to a pretrial without any problem at all. But if you're confused, you haven't reached a supervisor, you don't know what to do, and you're on the spot, set it for pretrial. You'll be all right. At this stage also, since the case has been filed, you can request a copy of the offense report from the county attorney. Under the rules of Texas, they are not required to give us a copy of the police report. Yes, sir?
Yeah, Dave. It says courts number 5 and 7 to ask for a pretrial hearing with witnesses. Okay. And you're saying without?
Well, that's only if you don't know which one to do. If you talk to your supervisor and the supervisor says, yeah, we want a real pretrial, go ahead and ask for a pretrial with witnesses. If for some reason you're caught in that default mode where you haven't been able to make the right contact, go to the pretrial without mode, and that leaves that option open of jumping past the pretrial to the TVC. Okay. The pretrial without setting is one that a couple of courts have created just to create a negotiating session. You know, nobody subpoenas any witnesses, but everybody brings their files and shows up, and they negotiate without having witnesses down there standing by. It's pretty useful. Okay? They're not required to give us copies of the offense reports, but as a matter of courtesy and efficiency, they will make us a Xerox copy of the offense reports. There's a way you can request those and send your materials. You can go to the county attorney's office, fill out a form, leave with the secretaries down there, theoretically come back a week later and pick up a copy of the offense report. Again, if you have not yet received it, you can again get the complaint information and probable cause affidavit down at the county clerk's office. Two subpoenas, well, nobody does for an announcement setting because it's nothing but an announcement setting. There's no hearing. There's no subpoenas. And you don't have to file any motions or forms for the announcement setting. It's just a telephone call. That's all it is. All right, so we've announced for pretrial, which is our normal mode. That's the next column. Pretrials are set at 9:30. That's the way the court set up their mornings. They start with announcements because a lot of people don't have attorneys at that first announcement setting, and they show up and they need more time. And just to get those people processed through the system takes about an hour at least. So the judges give from 8:30 to 9:30 to kind of work that part of the docket and take pleas and things like that and get those out of the way. And then they start their trial hearings at 9:30. Those are pre-trials and non-jury trials. Both of those are set at 9:30. So our pre-trials are set at 9:30. Let's follow that column down. Appropriate county court, again, whatever court it's assigned to. Again, it's the county court calls number, not that municipal court calls number. So when you file your pre-trial motions, you file them under that new calls number, not the old calls number. Physical appearance required. Yes, you and your client are required to be there. If your client is not there, the bond can be forfeited and a warrant issued for their arrest. We don't want that. When to phone? Well, we don't phone, we show up in person. Pleadings available? Well, we've already got all the pleadings. We've gotten that in the past. Now, who subpoenas? And here's one of the weird little glitches of our system. This is the only county in the whole world I've ever seen this work in. Normally, if a person, as a defense attorney, asks for a pretrial hearing and files a motion to suppress or any motion that requires evidence, the burden is on that attorney, since it's our motion, to subpoena the witnesses. And that makes perfect sense to me. And it's certainly the rule in our district courts, in our federal courts, and every other county court I've ever been in. However, for reasons that have not always been entirely clear to me, the rule around here for about the last 15 years has been that the burden is on the county attorney to subpoena these witnesses down there. Okay? That creates a unique dynamic because part of that rule is if first pretrial setting, their witnesses don't show up for our pretrial, say it's a DWI and it's the arresting officer, they can get one continuance, kind of a free continuance. If we show up at the second pretrial setting on our motion to suppress evidence, and they don't have the police officer there, the case could possibly be dismissed or reduced to a lesser charge, or the judge may just grant all our motions to suppress the evidence, thus effectively killing the case. We will win one case out of about 15 simply because of that. So you begin to see one of the reasons we set every single case for pretrial hearing, no matter how bad a dog it is, how bad a loser it is, because that gives us right there 1 out of 10 or 15 of every one of our cases that will win simply because the officer doesn't show twice in a row. It's playing a docket game. It's perfectly ethical. The judges know we're doing it. The prosecutors know we're doing it. And that's what we do. And all the good lawyers do it. The bad ones, they're too lazy to do it. So they don't take advantage of it. Now, that affects the filing of pretrial motions. Again, under the Code of Criminal Procedure in Texas, we know that if you file your pretrial motions 7 days before the pretrial, those are timely filed. Under the Travis County Court at Law local rules, because of this odd deal of the county attorney having a subpoena, we have to file our pretrial motions at least 21 days before the pretrial. That's so when the county attorney is subpoenaing these cases, which they try to do at least 2 weeks ahead of time, they will know which cases to subpoena. They'll be the ones with the motions to suppress in the files. And they go through they put all the files on the docket 2 weeks ahead. They look at everyone that has pretrial motions in it, they'll issue a subpoena on it. Okay? And that makes sense. They have to have enough time to do that. And what that means is that each one of y'all, in every one of your cases, when you set it, when you calendar your pretrial and say, you call tomorrow and they give you a pretrial setting 6 weeks away, you've got to put it on your calendar, not just that setting, but back it up 3 weeks and draw a big circle around that date and put on their pretrial motions in the Jones case due today. Actually, if you're smart, you'll back it up a week past that, 4 weeks ahead of time, so you'll make sure you get them in time. In practical matters of practicing lawyer, whenever you have a drop-dead deadline, whether it's filing an appellate brief or getting a petition in or whatever it is, if you have a drop-dead deadline, always calendar that drop-dead deadline a week sooner on your calendar, and your life will be a whole lot better in practicing law. If you calendar for that specific day, and if you miscalculate by 1 day, you can be dead. Or if something happens and everything jumps up, you suddenly realize you're too close to it, and you can't do a good job of getting done what you need, you're going to have troubles. I just, as a rule, back everything up like that 1 week before it's due. And that way, you get it done plenty of timely. If you run into a little bit of a jam, you've got a little extra slack. Okay? So my advice to y'all is when you get your pretrial setting, put that on your calendar, and then back up 4 weeks from that, circle that on your calendar, the pretrial motions due in such and such a case. All right? And we won't have any problems. Okay, the next column concerns the other kinds of settings we'll get after we've gone through pretrial. Pleas are set for 8:30. Again, if we've negotiated a plea and it's set for 8:30, yes, our client needs to be there for a plea. It's required that they enter their own plea. of the rules of court, and we need to be there. There's certain paperwork we'll show you how to fill out at a later time to get all that done. Jury trials are set for 9 o'clock, the morning of trial, and then trials before the court, we talked about, are set at 9:30. Again, we follow it down, location, and then whatever county court it's in, and the county court calls number. Physical appearance required, yes. When to phone, but we don't phone, we're going to be there in person with our client. Again, the next column is not applicable, we already have the pleadings. Now notice who subpoenas, the last part there. Well, at that point, that special rule about the county attorney having to subpoena their witnesses, that only applies to pre-trials. If you've got a case set for jury trial or trial before the court, and you feel like you need a witness there, you have to issue your own subpoena. Now, you understand the county attorney is going to be subpoenaing their witnesses, and you'll be subpoenaing your witnesses. We'll show you how to do that, and we'll work with you to decide who we need to have subpoenaed, how we get a subpoena issued through the clerk's office, and how we get subpoenas served. We'll teach you that and work with you on that. But we have to subpoena anybody we want up there for that trial. It's no longer any obligation on the county attorney. Motions or forms to be filed. Well, there are certain trial motions or plea documents. For the pleas, there's a certain set of documents we'll show you when we do the pleas. Actually, we'll show those to you next week. We're down at the corporate doing all that. The trial motions, those are normally things like motions in limine, something like that. That's generally the primary trial motion we'll have. It'll be a motion limiting. We'll always prepare those with the assistance of your supervisor before the trial. You want to worry about that. That'll be unique to that particular case. Okay. Now that's basically how the system works. It's designed to have a pretty good flow chart for the many thousands of cases that come through the system. It's going to seem a little confusing at first. Be sure to talk to your supervising attorney in each case and make sure you understand how the case flows through. After you've done a couple of these, they'll make sense. Okay, questions at this point? Everybody's got it? Yeah.
Once the case moves from municipal to county court, should you still get the complaint and probable cause affidavit from municipal?
I would, because the probable cause affidavit is sworn to by the arresting officer. You should always have that in your file because sometimes it is different than what's in the offense report, and sometimes you can impeach the arresting testifying officer with a prior inconsistent sworn statement that they made on the probable cause affidavit. Yes, you always want to get that. It should be part of your standard putting together and creating of your file. If you don't have it yet, if you got a file that doesn't have that,
yes,
go get it. The good thing is, once the case has been filed at county court, you can get a copy of it down at the county court too. The county clerk will have a copy in their file also. So you don't have to go down to the municipal court. Just get it at the courthouse while you're down there getting the rest of your stuff. It'll be down there also. Any other questions? Okay, let me ask you all a question. If you set a pretrial, how many days before the pretrial do you need to file your pretrial motions? Somebody?
21 days.
21, but then your rule of backlog and everything.
I'd say 20. You got it 21, or you die. 28 days is really the best way to do it. Give yourself an extra week. All right? And just, we hammer that into you because, I mean, every semester we get about halfway through the semester, and some student calls up, oh my God, I just realized it's 14 days before pre-trial, I'm just now filing my pre-trial motions. And it's not the end of the world. We get one free continuance too on this. It's a pretty forgiving system. Our first pre-trial setting, we walk up and say, Judge, we're going to burn a continuance on this. The judge wanted to ask us why. We don't even have to tell him we screwed up and file our motions in time. But we burned a continuance that maybe the state would have had to burn a continuance on. Because their officer wasn't there and they're kind of thinking, ooh, we dodged the bullet on that one. You know? And you don't want to get a reputation of not getting things filed in time. You don't want to get a habit of not getting it time. So you always want to get this stuff done. Okay?
Isn't it possible to have multiple pretrial hearings too? I mean, that just...
Well, the prosecutors don't, the judges don't want to have multiple hearings because they're overwhelmed. So they try to get everything done in one hearing. But sometimes you will have multiple hearings. Most often what you'll have in the way of multiple pretrial hearings is two situations. The hearing requires, say, one officer does the stopping and the other does the arresting, and they're both necessary to hear all the motion on motion suppressed. And sometimes the judges say, we've got one officer here, let's take Officer A today, We'll take officer B the next time. So you do half of it today, and you come back and do half of it the next time. The other time you'll see it is when the judge will hear all the evidence, and there'll be kind of a point of law the judge is unsure about, and the judge will say, you know, I'm going to take this under advisement. I'd like the whole size of certificates and cases and briefs. I'm going to set it 2 weeks away, and y'all come back, and we'll argue based on your briefs and cases after I've had a chance to read those. And that's the other kind of split pretrial we tend to see more often. Okay. All right. Any other questions on how the system works? Again, you will have questions about this. That's fine. We expect you to have these questions. If you have a question, call your supervisor. On calling the supervisors, like today, I know somebody tried to call me, whoever it was, grabbed me at intermission here, but I was in court all day long and had to run up to Williamson County and come back to court on a clinic case that we didn't finish until after 5 o'clock. It started at 9:30 and we finished at 5.
Don't be asking for overtime.
That's right. It's all your fault. But sometimes I just can't get back to you the same day. But if it's a quick question or something you need to talk about, call one of those supervisors or call Shub. It's okay. I mean, if Bill's out of town or unavailable and something on his, call me. I'm there. I'll be glad to talk to you and answer your question if I can. You know, we're kind of fungible items to a large extent that supervisors are. And treat us that way, and feel free to call us on any questions.
I generally don't return phone calls when it gets above 110 degrees in the sun.
Did you talk about pretrial conference?
No. And I'm glad you reminded me of that. Court 6, and it's not on the sheet anywhere, has a new and separate creature called a pretrial conference. Judge Breland created this because she felt pretrial was being abused, pretrial settings, bringing witnesses up there, but really it was just a negotiating session. And instead of doing a pretrial without witness setting, she does a pretrial conference setting. And she sets those on Thursdays and Fridays only. So you can't set them on Tuesdays. Like we told you to set everything on a Tuesday, right? You cannot set a pretrial conference in Court 6 on anything but a Thursday or Friday. Here's my suggestion to you. Set them, if you possibly can, on Friday morning. You don't have to do this. But I, as a supervisor, will almost always be up there on a Friday morning. That's generally what I set my district court cases on Friday morning. And I'll almost always be up there. Everybody's in a little bit better mood on a Friday morning. The judge doesn't get involved. It's just where you show up and you grab the file, you sit on the prosecutor, and they give you discovery. You give them discovery. You talk, you snooze. If you can settle it, you settle it. If you can't settle it, you put it on the pretrial. It's just a new step in there between announcement and pretrial with witness. Judge Breland extracts out of us. I don't know that it does a lot of good, but it's okay. So when you call up for Court 6 on the announcement setting, they will give you, unless the only thing you set it for is a plea, are a pretrial conference. We're not going to set it for a plea. So they'll give you a pretrial conference. You'll say, you want a Thursday or Friday? You want a morning or afternoon? I would say put it on a Friday morning. But it's better for you to have class, and Thursday afternoon is better for you, or Friday afternoon. That's okay, because we don't need to be there. It's just a negotiating discovery session for you guys, and the supervisor does nothing to get that setting. Okay?
Let me explain why these pretrial conferences make no sense. In the other courts, you can get a copy of the offense report earlier in the process, and you can go out and check out the case and investigate it and figure out what you want to do with it, so you can come in ready to negotiate. But in Court 6, they won't give you a copy of the offense report until you show up at a pretrial conference. Well, so the defense attorney is left in the dark until they show up for this conference, so they're really in no position to negotiate because most of the time they know very little about the case. At the same time, the prosecutors in Court 6, more than any other court, are not really interested in negotiating cases out. They tend to make these outrageous offers and aren't really serious. So this whole process, as far as I can tell, doesn't serve any point. Did you talk about pre-trials without this concept of pre-opening? And jury trials definitely in Court 6 definitely?
Well, that's too complicated. We'll talk about the jury trials. As you get your jury trial settings, they have kind of a unique, strange way of getting set. Each court has its own little rules on that. And your supervisor will just guide you on that. I mean, it's too complicated to talk about right now. But when we get to the jury trial, we'll work that out for the individual.
Let's go ahead and I'm going to divide you into 3 groups, and
Each of you are going to go off in a group and meet with the supervisor and talk about your cases. So during the 10-minute break, you'll get all your case files and you can go to wherever your designated places. The people meeting with Bill are Andrews. Is it DeGive? Am I pronouncing it correct? DeGive, sorry. Should have known. DeGive, Deneen, Evans, Golden, Grimm, Hearn, and Holland. Meeting with Bill where?
Let's just go to clinic library.
Holt, Huff, Johnson, Luke, Kelly, Helene, Martin, McGrath, and Miller meeting with Dave.
This is fine right here.
Molina, Mott, Kinsey, Rushing, Ryan, Tomasin, Sy, and Whitmire meeting with me in my office, which is 1.310B on the first floor of the Comedy Building.
Who's got Clayton Baker?
Who's got Dorsa Gariba? Get our back.
Clayton Baker.
Right here.
Senior is the original.
Okay.
Let's make a break, or may not be.